Hi, this is Steve Wagner, and this is a quick discussion on employee discipline and arbitration that is often associated with it. Now, in most union management contracts and agreements, there exists lots of opportunities for management in the union to come to some agreement about discipline cases. There's many stages in that discipline process for there to be some agreement about the specific individual's cases. But often you don't get that agreement because there's an adversarial nature to the relationship and there's a duty to represent each side, management representing the business and the union representing the employee. And so there often has to be a third party invoked to come to some agreement, and that's why oftentimes you see the use of arbitration to settle discipline cases when there is a collective bargaining present. Now, even when you aren't dealing with a union, there are many kind of contingencies to this employment at will relationship that we hear so much about. There is employment at will, but there are a lot of caveats to that. And so executing discipline and when it involves termination specifically, there's the need to really focus on risk management. What are the benefits and costs associating with acting and of course of not acting? You have to think on both ends there, but there is a cost benefit equation that you need to think about, and some of that involves arbitration. And again, the idea I think here throughout this is to be proactive and avoid and minimize the risks through proper procedures that are executed with discipline. Now, arbitrators have three areas of power that help them make decisions in regard to employee discipline cases. First, they have power in determining what constitutes just cause for discipline. They also look at and determine what are the appropriate standards for proof and evidence. And they also review and modify and sometimes eliminate penalties imposed by management when that is warranted. A number of times in class, we've talked about what employment at will means. Again, this is the standard employment relationship in the United States, that either party in the relationship can sever or stop the relationship at any time for no reason at all, for no reason, just as the employee can terminate the relationship for no reason. Okay, but in reality, there are a number of exceptions to employment at will that have come through different legislation. I mean, we covered much of this legislation throughout this class, and talking about, of course, the Wagner Act and the labor legislation that gave workers the right to collectively bargain and therefore set different standards for that employment relationship. And then civil rights legislation also changed the employment at will relationship. That you can't fire a person because of their race or their sex or their age. If that is the particular reason, that is illegal, and so that's an exception to employment at will. Other public policy reasons, if a person is asked to violate some kind of law at the federal, state, or local level, that is an exception to employment at will. You can't be fired because you refuse to violate a law. There can also be exception to employment at will, a case made if there has been an implied contract, if there is evidence of some other kind of agreement, maybe a spoken oral agreement about how safe your job is, that could be used as evidence, and a case could be made as an exception to employment at will. Another exception that you'll see for this employment at will relationship happens on a kind of a state-by-state basis, but also you see this within unions in general. The discipline, the termination decisions have to be made with just cause. This kind of exception we also see in many states, whether there is a union or not a union in a particular organization. The state has a standard for an exception of the employment of will, that there has to be just cause, a fair dealing when there is a discharge of an employee. So termination decisions can ultimately be decided by an arbitrator. And again, this is a labor relations class, so we're talking about that this relationship often occurs in the discipline cases under a union contract, but even in non-union companies, the decisions about discipline and about employment can be subject to an arbitrator's decision because the standard of employment at will has exceptions, both at the federal and at the state level, and violations of those can lead decisions to be decided by an arbitrator. Arbitrators have options in terms of making decisions in the cases. They can either uphold the management decision to terminate the employee, or they can reinstate the employee with some or all back pay. Now, being on the losing side of an arbitrator's decision for management is really a setback. There's, of course, can be the financial loss of back wages, but then there's the loss of authority over that reinstated employee, even if it's just at a psychological level. The employee may fail to perform well because they feel like they're untouchable in some way, and there can be a loss of faith through the ranks of the management of the organization. So again, the big lesson here is that whether you're dealing with a union or not, you don't want your termination or discipline decisions to be overturned by an arbitrator, so you really should take them seriously and have solid procedures that are executed with discipline. And so there are times when we have to discipline employees. People are human and people misbehave. And as managers, part of our responsibility is managing that behavior. So there are legitimate times to terminate employees. And it's important that we maintain respect and authority throughout that process. Because what we're doing is we're setting an example of what's appropriate behavior, and we're communicating the rules of the organization and what happens when those rules are violated. Through that understanding, there is more efficiency in the organization, and there is a respect for the authority of supervision. And we are taking an active, proactive way of correcting employee behavior, which is sometimes something necessary that we have to do. And one of the main things that an arbitrator is going to look at is the elements of just cause. And the question is going to be, was the decision for discipline made with just cause? And there's three elements to this. First, the arbitrator is going to ask whether the decision to discipline was valid. Is there evidence that there was a reason to discipline? Next, the arbitrator is going to look at whether the punishment was appropriate or fit the offense. And then third, the arbitrator is going to look at whether or not there was bias in the execution of the discipline process. Now, research has uncovered many more specific ways that just cause has been defined by arbitrators. And so this slide gives you a list of those criteria. They include notice, whether the employer gave employees appropriate forewarning, knowledge ahead of time about the consequences of discipline and conduct, whether the work rules were reasonable and orderly, whether there was an investigation of the employee's conduct and whether that was a fair investigation, whether the proof really did contain substantial evidence that the person being disciplined was in fact responsible, whether there's equal treatment of employees in similar instances where these rules are evoked, and whether the penalty given to the employee was actually appropriate. And again, this goes on to look at other areas. If any of those are answered yes, we can look at the process by which, or the hearing for discipline, whether that was fair, and whether there was really a consideration of mitigating